Good day, and welcome to today's teleconference. I'll now turn the program over to Yale Hauptman. You may begin.
Thank you, Nathan. Good afternoon, everybody. Welcome to the latest installment in our teleseminar series. Today's topic is Medicaid planning for married couples. And before I get right into it, I think for the benefit of everyone, we've spoken or we've talked about the DRA, the Medicaid changes under the Deficit Reduction Act, which occurred last year. But to give everybody a base of knowledge, I'm just going to go over some of the highlights that of those changes in the Medicaid laws that occurred last year, so that we can then get right into how Medicaid treats married couples. In February, specifically February 8th of 2006, President Bush signed into law the Deficit Reduction Act of 2005, which contained some pretty significant changes in the Medicaid laws, not for the better for the Medicaid applicants, your clients and patients, but for the worse. And specifically, to highlight some of those changes, Medicaid's a needs-based program, and in order to qualify, you've got to meet certain asset and income tests. And one of the things that the new law did was to try to restrict and prevent people from protecting their assets and transferring some of those assets out of their name. Under the rules, if you transfer assets out of your name, what most people would consider a gift, but it's not only limited to gifts specifically, it's a transfer for less than fair value. An asset is transferred out of one's name and nothing of equal value is received back. Medicaid counts that as a transfer and calculates what they call a penalty, which is really more accurately a period of ineligibility. And that's based on the amount that is transferred divided by the average cost of nursing home care in the state, which is updated periodically. Right now that number is $6,525, which generally is a low number, but that is the number that the state uses. So if I were to transfer $100,000, divide that by 6,525, and I would get a number of 15.3. Now, previous to February 8th, 2006, that 15-month penalty would have started when I made the transfer, and the clock would have started counting on that penalty from that point in time. However, under the new rules, since February 8th of 2006, that penalty does not start when I make the transfer, but at a later point in time. That is, after I have no more money left and I need nursing home care and I apply for benefits. Then the penalty kicks in at a point when I have no more money left to pay for the care, thereby causing me to have to bring that money back into my name and use it for my care. So that is a pretty significant change, and let me now turn to how Medicaid treats married couples. Now, what happens is if I have a situation where I've got, let's say, a husband who needs nursing home care and a wife who's healthy. The husband is considered what's called the institutional spouse, and the wife in this example would be the healthy spouse. What Medicaid does is they take a snapshot of the couple's assets. It does not matter who owns the assets. So in other words, if I need care and my wife is healthy and everything is in my wife's name, all of our assets are in my wife's name, it doesn't matter. They count, they combine the assets together and treat the married couple as one unit, if you will. Now, what then happens is there is what's called a division of assets. Now, the value or the snapshot that is taken of those assets, because the assets can and often do fluctuate from day to day, month to month. So the question is, when do they value those assets? And the answer to that is as of the first day of the first month that the person is continuously institutionalized in a nursing facility. And so they value all the assets as of that date. Now, there are certain assets that are exempt, that are not counted as part of this snapshot and calculation. Primarily, that's a house, as long as one of the married couple is still living in the house. Prepaid funeral burials, as long as they're irrevocable, and $1,500 of cash value. Other than that, everything else is generally going to be counted. And so they add up those assets, and you get a number. Now, what happens is they divide that in half. So in one column, half of the assets are the husband's and half are the wife's. So let's say that we've got a couple that has $150,000 in assets. Well, what happens is we divide that in half. $75,000 goes into husband's column, $75,000 into wife's column. Husband has to spend his $75,000 down to below $2,000. Wife will be able to keep her $75,000. So in the end, they'll be able to keep $77,000. Now, that's basically the way the division of assets works. However, there is a limit to what the healthy spouse can keep, and that number just went up to $101,640. What that means is that when the assets are totaled together, the wife gets to keep one half, but only up to that maximum amount. So in other words, if the couple has $300,000 in assets, you divide that in two, and you would think, well, the wife gets to keep $150,000. That's not correct. The wife can only keep one half up to the $101,640. So in other words, in essence, they will have to spend down almost $200,000 of assets and only get to keep about $103,000 of assets. That is without any sort of planning. Basically, that's the way the rule works. Now, income is treated a little differently. Income is considered what's called the name on the check rule. Medicaid does not combine the income together, but they consider who is the recipient of that income. Mostly that income is going to be considered Social Security and pension, because remember, any income from investments is going to be spent down, and it's going to generally disappear except for whatever the healthy spouse is entitled to keep, and so whatever income that throws off is going to be hers. Now, when you get that number, there is a maximum amount that Medicaid, well, actually, New Jersey has two Medicaid programs. There is a medically needy program and a Medicaid-only program, so that if your income exceeds $1,809, soon to go up to $1,869, then you qualify for the second program if your income exceeds that amount. In addition to that, let's say we have a couple and husband has income of $1,500 and wife has income of $600. The wife will be entitled to keep a certain portion of the husband's income, and this is what's called the minimum monthly maintenance needs allowance. Right now that number is $1,650. So what that means is that we look to see what income does the wife have. In our example, she only has $600 of income. Therefore, she is entitled to take a portion of her husband's income and keep that to bring her up to the $1,650 a month number, and anything else that the husband has in the way of income will then go to the nursing home. In addition to that, there are certain utility and shelter allowances that are taken into account that may allow the wife to keep even more of the income. But even with those excess, what are called excess shelter allowances,